Welcome everybody. Thank you for joining us for today's online talk entitled Enforcing an Adjudication Decision, Direct Payment from Principal. My name is Rachel. I am an associate with Marvin Bright and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce you to the firm and what we do. Before I begin my introduction, I would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Let me give you a short introduction of the firm and what we do. Marvin Bright and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Hui Guai. Our able team today comprises of 31 lawyers and support team of 23. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on serving the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolutions team. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our 15th talk in our online talk series in 2023. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, details of which will be given at the end of this talk. We have one speaker for today, and after the speech, we will conclude with a Q&A session. Allow me to introduce Michael. Michael Paul is a senior associate in our dispute resolution department. He graduated with a Bachelor of Laws from the University of Leeds and was admitted to the Malaysian Bar in 2013. He also did the Bar Professional Training course at Nottingham Trent University and is a member of the Honourable Society of the Middle Temple. Michael's area of practice include construction, general litigation, debt recovery, arbitration and adjudication, and employment. Today's talk points are an overview of CIPAA, the direct payment from principal under Section 30 of CIPAA, our third talk point being opposing a demand of direct payment, and the last talk point is other ways to enforce an adjudication decision. I will now hand over the session to Michael.
Thank you, Rachel. Before I start, first and foremost, good afternoon, everyone. Thank you for tuning in. I hope most of you who are attending today's talk are familiar with CIPAA, but for the benefit of those of you who may not be that familiar or who may be new to the industry, to the construction industry or the legal industry, let me just give you a very quick, speedy introduction to what CIPAA is or what adjudication is. Adjudication is basically a statutory alternative dispute resolution created by the Construction Industry Payment and Adjudication Act 2012. It came into force on the 15th of April 2014. It is in essence a dispute resolution process which gives parties speedy resolution, and this is specific to the construction industry. This process gives you a temporary decision. What I mean by that is that the adjudication decision is binding until the matter is fully heard by the court or arbitration, and after a court decision or an arbitration award, the adjudication decision is no longer binding. When I say a speedy or quick resolution, I think this relatively, because typically the adjudication process provides a very strict timeline according to the provisions. As you can see on the screen or on the slide that I shared, the mapping out suggests that from the moment you issue the notice of adjudication, you should, under normal circumstances, receive an adjudication decision within 90 working days. That basically translates to about 4 to 5 months, depending on the season of the year. Some days you have longer holidays, which don't fall as working days and push the timelines back a little bit. One thing that is special, or I would say unique about CIPAA is that it also provides for special or rather additional remedies under the Act, which for subcontractors. For example, after the adjudication decision, there is a statutory right to suspend or reduce the rate of works or progress of performance that's covered under Section 29. And also there is the right for parties to go and seek for direct payment from the principal in Section 30. Section 30 is what we will be discussing on today. Now, before I go into discuss the provisions, there are basically 5 sub-paragraphs, sub-clauses under the Act, under Section 30. But I will be discussing examples where the construction contract is between a developer, main contractor, and subcontractor. So all my examples will be given from that general position. I say this general position because adjudication is not limited to just a subcontractor bringing a claim against the main contractor. No, in fact, a main contractor can also bring a claim against a subcontractor. For example, if the subcontractor fails to carry out works and the main contractor has to then send in a replacement or a rescue contractor, it carries out those works, the cost it has incurred to carry out those works is claimable. And so a main contractor can also initiate adjudication proceedings against a subcontractor. But by and large, it's usually the subcontractor who claims against the main contractor. Okay, jumping into Section 30. Basically, this is what the provision says. If a party against whom an adjudication decision was made fails to make payment of the adjudicated amount, the party who obtained the adjudication decision in his favor may make a written request for payment of the adjudicated amount direct from the principal of the party against whom the adjudication decision is made. You will notice that there is the word principal in the Act. You may ask, who is a principal? In the example I've given earlier, developer is usually the principal of the main contractor. The terminology principal is defined under the Act, Section 4, which says party who has contracted with and is liable to make payment to another party where that other party has in turn contracted with and is liable to make payment to a further person in a chain of construction contracts. For example, if a developer of a condominium engages ABC company as a main contractor and ABC in turn engages XYZ as the plumbing subcontractor, if the main ABC doesn't pay XYZ initiates adjudication proceedings and succeeds. Let's say he succeeds. The adjudication decision will say that ABC must pay XYZ 1 million within, say, 30 days of the award. Now, if ABC does not pay XYZ within the time frame, XYZ can then exercise its right within Section 30 of the Act and make a demand from the developer for that $1 million, even though there is no direct contractual relationship between the subcontractor and the developer. A question that has come up on who the principal is, what happens in a situation when the developer, say, terminates the contract with the main contractor? Is the developer still then liable or susceptible to a Section 30 application, direct payment application? Now, this happened in the case of Global Tech Engineering against Panzana Enterprise. The defendant, developer, Panzana, subcontracted its works to MKP, and MKP in turn subcontracted the works to Global. Now, there was a dispute, and basically, Global was successful against MKP. The adjudication decision was delivered, and MKP, the main contractor, failed to make the required payment within 14 working days. The plaintiff then requested for direct payment from the defendant as per Section 30. That means a direct payment request. The developer didn't respond, he ignored the request, and later the plaintiff sued the developer. Now, the developer, in its defense in court, argued that the request is invalid because they had terminated the contract between the main contractor and the developer. So they argued then that because by virtue of the termination, I am no longer the principal as defined under the Act, and therefore I am not responsible to pay, or I'm not liable to pay a direct payment request. Now, this is what the court held. The court said that this argument does not hold water, as there is no express provision in CIPAA stating that the Act in general or Section 30 in particular does not apply in situations where the construction contract has been terminated. The termination of the contract between the defendant and MKP, the main contractor, does not affect the defendant's position as principal to MKP. And therefore, the defendant falls squarely within the definition of principal under CIPAA. So, if you are faced with a situation where, assuming you are the subcontractor and your main contractor doesn't pay you the adjudicated sum, you can go after the developer for the payment. And if the developer says, oh, I've terminated, I'm no longer a party to it, that is not a valid reason. So take note, you can still go after the developer, notwithstanding any termination between him and the main contractor. So if you are in the shoes of the developer, or the principal rather, what do you have to do? Now, the Act spells out the obligation under Section 30 sub 2. Upon receipt of a written request under subsection 1, the principal shall serve a notice in writing on the party against whom the adjudication decision was made to show proof of payment and to state that the direct payment would be made after expiry of 10 working days of the service of the notice. What this section is basically is, if I, the developer, have received a letter from you, the subcontractor, saying that I have an adjudication decision, the main contractor has failed to pay me, refuses to pay me, then I, as the developer, have an obligation to write to the main contractor and say, and ask him, hey, you need to show me proof that you have paid the subcontractor of the adjudicated sum. Now, what happens if the main contractor does not respond to my letter? Section 30 sub 3 provides that if, or rather the words of the Act, in the absence of proof of payment requested under subsection 2, the principal shall pay the adjudicated amount to the party who obtained the adjudication decision. I.e., if I am the developer, I sent out this notice and I do not receive any proof of payment by the main contractor showing the main contractor has paid the subcontractor, then the developer has a liability or an obligation to pay the subcontractor directly. So what is the recourse for the developer that I, in the first place, do not have a contractual obligation to pay the subcontractor? I have not assigned that risk of non-payment to the subcontractor to myself. That is actually borne by the main contractor. So what is my recourse here? So the developer, notwithstanding having paid the subcontractor, still has the right to recover the monies from the main contractor for payment that it has provided for. So Section 30 sub 4 provides that the principal may recover the amount paid under subsection 3 as a debt or set off the same from any money due or payable by the principal to the party against whom the adjudication was made. So if I, the developer, basically still have to pay the main contractor, say, 1 million for progress claim, I have that right to deduct whatever monies I paid to the subcontractor over the 1 million that I owe the main contractor. It is pertinent to note that Section 30, a direct payment claim, applies only when there is money due or payable by the developer to the main contractor at the time the notice was received by the developer. If there is no money due or payable, the developer may oppose any application by showing proof that there is no money due or payable to the main contractor. The burden is on the developer, meaning to say it is not for the subcontractor to prove that the developer has money, or rather the main contractor has money due from the developer. It is the developer who has to show that he doesn't have any monies due to the main contractor. Now, I draw your attention to the way the words of Section 30 sub 5 is phrased. It says due or payable. The operative word being or. Basically, the courts have held that there are two separate limbs under Section 30 sub 5. Under the first limb, the word due is easy enough to understand, which is basically if I, the developer, have an obligation under the contract to pay or honor any certificate issued within 30 days of the certificate being issued. Upon the 31st day, I do not pay, then that is due. That is the simple understanding of what due means. However, the word payable, on the other hand, is wider. The courts have held that an amount may be payable without being due, because debts are commonly payable long before they are due. Basically, what this translates or suggests is that if I have, for example, the developer, I'm still holding on to the second moiety, the retention sum, second moiety, the last 2.5%, which is typically released only after is issued or the defect liability period has finished. Now, I'm holding on to that money. It is not due yet until the CIMGD is issued, a certificate of making good defects is released. However, an action for Section 30 can still be brought against me, and I still have to pay because that retention sum is payable to the main contractor. So even though it's not due yet, it is still payable, and therefore I cannot argue that this entire Section 30 does not apply to me by virtue of Section 30 sub 5. Now, as the developer, what if I take the position after I receive the Section 30 notice from the subcontractor? What if I take the position, hey, I don't owe you money, I don't owe the main contractor money in the first place. I don't owe him whether it is due, whether it's payable. It's not due, nor is it payable. What then do I have to do? Do I just write to the subcontractor and tell him, I'm sorry, Mr. Subcontractor, there's no money due or payable to the main contractor, and just leave it at that? The answer is no. You have to understand that it is pertinent that the Section 32 requirement, which is that notice that you have to write to the main contractor and ask for proof of payment, is a statutory requirement. It is an obligation that you must follow. If it would be wise for you to issue the notice, because failing or ignoring to do so could have serious ramifications if you are sued by the subcontractor later. If you are sued by the subcontractor and you raise a defense, there is no debt due or payable, but you still didn't issue a notice pursuant to Section 30 sub 2, it can be, and it has been held to be fatal to a defense that says that there is no debt due or payable. Now, an example is this case of HMN Nadir Sendirian Berhad against Jabatan Kerja Raya Malaysia. In that case, the principal did not issue a notice pursuant to Section 30 sub 2, and later on raised a defense that said that there was no debt due or payable. Now, the court rejected the principal's defense, and among the considerations taken into account was the fact that they failed to issue a notice under Section 30 sub 2. Justice Lee Swee Seng, who is now federal court judge, said that the deliberate breach of Section 30 sub 2 does not obstruct the continuation of the direct payment mechanism under Section 30 sub 3. And therefore, the principal shall pay the adjudicated sum. He went on to say that there can be no proof of payment as the defendant had failed or refused to issue the notice pursuant to Section 30 sub 2. And he agreed with the plaintiff's submission that the defendant cannot rely on its own breach of Section 30 sub 2 to avoid a mandatory obligation to make direct payment under Section 30 sub 3. So following that decision, the courts have taken a very stern view over non-compliance with Section 30 sub 2. Another example I would give you is this case of HSL Ground Engineering against Civil Tech Resources. Now, similarly, you have a situation where the plaintiff, being the subcontractor, was appointed by CTSB, but CTSB failed to make full payments under the contract, and the plaintiff initiated adjudication proceedings against CTSB. The plaintiff was successful, but CTSB still refused to make payment. The plaintiff then asked for direct payment from the defendant, who is the principal, who argued that they had already paid CTSB based on progress certificates, and no further payment was due, asserting the fact that it was actually CTSB who owed them money as per the final accounts. Now, because the court held, since the plaintiff had procured adjudication's decisions, the plaintiff had a statutory right to request for payment under Section 30. Towards this end, the plaintiff had pursuant to Section 30 sub 1 of CIPAA, served on a request of the defendant, and in consequence, the defendant was required under Section 30 sub 2 to serve a notice in writing to CTSB to show proof of payment and to state that direct payment would be made after the expiry of 10 working days of the service of notice. It was mandatory for the defendant, the developer, to issue such a notice under Section 30 sub 2. However, since the defendant failed to comply with Section 30 sub 2, it was bound to pay the adjudicated sum pursuant to the adjudication decision to the plaintiff directly. The court went on to also find that failure to do so is fatal to the defense against the plaintiff based on Section 30 sub 3, and nonetheless, even if Section 30 sub 3 was still to be read together with Section 30 sub 5 of CIPAA, it was presumed, there is a presumption that the plaintiff had not been paid by CTSB. In other words, the court has taken the approach that if the principal does not comply with the statutory requirements under Section 30 sub 2, the obligation under Section 30 sub 3 is triggered automatically. You cannot argue that, oh, because I didn't issue any notice or no notice pursuant to 32 was affected, therefore 30 sub 3 does not engage. That is not the argument that the courts accept. In fact, as we have seen in those two cases, it is fatal, because once the courts take it as you have not complied with Section 30 sub 2, your defense that there's no money due or payable is severely affected, I would say. So even if I, the developer, take the position that no money is owed, I nevertheless must still write to the main contractor and ask for proof of payment, the subcontractor for the adjudicated sum. Otherwise, my grounds for defense later at a later stage will probably fail because I have not complied with statutory requirements. It is strongly advisable for any developer to just comply with the requirements of Section 30 sub 2. Having discussed the obligations of the developer insurance response pursuant to Section 30 sub 2, I move on to this question where the subcontractor, or rather, if you, the subcontractor, receive a decision, what do? Do you need to enforce it first? Do you need to apply for it to be enforced under Section 28 first before you effect a request under Section 30? The answer is no, because Section 30 is quite separate relief, I would say, or a separate procedure for you to undertake altogether compared to an enforcement proceeding. So just to give you an example, if let's say you've got an adjudication decision and you are weighing your options, should I go for garnishee? Should I go for writ of seizure of sale? Or should I go for a direct payment? Now, if you're not sure, the answer is you can actually go for an execution, i.e. maybe a garnishee, and a request for direct payment concurrently. You are not precluded from choosing one over the other. I will go more into this later, but in essence, you can take the action of Section 30 concurrently while you apply for an enforcement under Section 28. You are not precluded from bringing a direct payment claim just because you have not yet taken steps to enforce the decision under Section 28. Now, this position was considered and held in the case of HMN Nadir against Jabatan Kerja Raya, where the court held that nowhere is it stated that the remedy under Section 28 must first be applied for and obtained before the successful payment can proceed under Section 30. If that were the requirement, Section 31 and only of ornamental value. The legislature must be presumed not to waste words or not to use them for pure decorative purposes. Concurrently cannot be read as sequentially or consecutively after exercising its remedy under Section 28 of CIPAA. So what is Section 31 that was referred to in the case? Basically, Section 31 provides that unless a state is granted under Section 60, decision in its favor may exercise any or all of the remedies provided in this Act concurrently to enforce the adjudication decision. The remedies provided by this Act are without prejudice to other rights and remedies available in the construction contract or any written law, including any penalty provided under any written law. So earlier, while discussing the requirement of whether or not you had to apply to enforce the adjudication decision before you went for direct payment, I had alluded to bringing concurrent actions. What if the subcontractor were to sue the main contractor in court after the adjudication? He can still bring an action, separate action against the main contractor in court or arbitration, and then concurrently sue the developer for the sums under direct payment. Can he bring both actions at one go? Now, this is what happened in MCC overseas against Kinsa Nuri. Now, in opposing the enforcement application, Kinsa Nuri argued that the main contractor, argued that the subcontractor was in essence seeking double payment, both against the main contractor and the principal at the same time. And therefore, they argued that this amounted to unjust enrichment. Now, the court held that the argument that the subcontractor was seeking double recovery or unjust enrichment was incorrect and misconceived. The court held that MCC's actions, or subcontractors' actions, were in compliance with CIPAA, which allows for the exercise of the remedies concurrently. So the answer to the earlier position is that yes, you can bring two proceedings separately. However, I draw your attention also to another case, which is JDI Biotech against Danga Jet Development. The reason why I draw your attention to this case is the opposite decision was delivered in this case, whereby the general facts are by and large the same, where there was an adjudication decision obtained, the main contractor didn't make payment, subcontractor then sued the main contractor in the High Court and also asked for direct payment, applied for direct payment against the developer. However, in this case, hearing the application for direct payment, i.e. the application against the developer, the High Court rejected the application for direct payment on grounds that in granting this application could potentially lead to a double recovery. If the court hearing the suit against the main contractor also enforces the subcontractor's actions. So here you have two differing decisions, and unfortunately, I would say the position is not really settled because both decisions are at the High Court level. However, I would suggest that there are more cases that say that you can bring an action concurrently and that there is no issue of unjust enrichment. And also because, as we highlighted earlier, the Act expressly provides that you can bring an action concurrently. I think in JDI, the case which this held that you couldn't bring an action concurrently. This decision perhaps has to be looked at carefully, because if you read that decision, that case carefully, it was also established, or rather the court found, that there was no debt due or payable in that case. So in any event, that case would have failed because it failed to meet the requirements of Section 30 sub 5. Now, there are other ways you may enforce an adjudication decision. You don't have to just go for a Section 30 request. You may apply for an enforcement within Section 28, pursuant to Section 28, so that you can then exercise your rights to execute the court order in accordance with the rules and execution procedures that are available under normal circumstances. So that means you can proceed for garnishee, seizure, sale, or even ask for judgment debtor summons. You may also want to consider that you can bring winding up proceedings as an alternative method to recover the money against the main contractor. And for winding up proceedings, you do not have to go for an enforcement application first, as in you do not need to go by way of Section 28 to enforce it first before you start winding up proceedings. The Court of Appeal has already held that a successful claimant in CIPAA may issue a statutory notice of demand and proceed to wind up a company based on the adjudication decision without having even to enforce the decision pursuant to Section 28. Thank you.
Thank you, Michael, for your insights in enforcing an adjudication decision. Thank you also to Aisha and Megala for assisting us behind the scenes with the preparation of this talk. We will now be taking questions from the participants which have been posted in the Q&A box. For participants who have not posted your questions, you can click on the Q&A box at the bottom of your screen and you can post your questions there. We will now start with the first question. The first question being, Michael, earlier when you were talking about the principle, the case highlighted was when the developer had terminated the contract before it received the Section 30 notice. What if the developer terminated the contract with the main contractor even before the adjudication proceedings had started?
Okay, actually the case cited earlier when I was giving that example, Local Tech Adzana, the developer actually did terminate the contract, the main contract, before the payment claim was served. So it appears that even if the main contract between the developer and main contractor was terminated before adjudication proceedings even began, the developer is still caught by the definition of Section 4, which is the definition of what principle is.
Thank you, Michael. Now I move on to our second question. It's pretty short. So can the subcontractor go against the main contractor's holding company as the principal?
All right, okay. So for this, I would argue no, because the definition of principle for you to enforce Section 30, a direct payment, the definition of principle does not extend to holding companies. It extends to a party who has contracted with and is liable to make payment to another party in a chain of construction contracts. So unless the situation is such where the holding company happens to also be the developer, then the answer is probably not.
Thank you, Michael. I'll move on to our third question of the day. What if the main contractor had gone into liquidation? The money owed by the developer to the main contractor should be paid to the company for the liquidator to pay off all the creditors. If the developer is served with the Section 30 notice, can the developer still pay the subcontractor under Section 30?
This issue actually has been considered in the Court of Appeal, actually. I think the case is City Indah Construction against BHL Gemilang. Basically, the issue here is whether or not there is preferential treatment if the developer pays directly to the subcontractor, because the main contractor is already wound up at the liquidation and the developer is using monies that's presumably owed or payable to the main contractor, and instead of going to the normal pool, it is now going directly to one creditor. So whether or not that creates or is in breach of preferential payment rule. The answer to that is, in that case, it was held that the developer's liability to make payment is a statutory obligation as imposed by the Act, and therefore it is an independent obligation altogether, and therefore it's not running from the assets of the main contractor, and therefore it is not in breach of any preferential treatment rule.
Thank you, Michael. I'll move on to our fourth question. What happens if the main contractor has no money left from principal? Basically, the principal does not have any money that could be deducted, which is owed to the main contractor. What can, I suppose, a subcontractor do if that happens?
So can I just clarify this? When it says that there is no main contractor has no money left from the principal, where principal cannot deduct. Oh, meaning to say that the main contractor says already in liquidation or has zero money whatsoever. The obligation still remains, provided that you have monies due, or the keyword again is or payable. So Section 30 sub 5 says that this clause or this requirement is applicable. I'm paraphrasing here. It's applicable if there is monies due or payable. So if the developer is holding on, say, retention sums, I give the example of retention sum because that is usually the last payment. The main contractor has no money in the accounts, they are already in liquidation. Can the developer or is the developer obligated to pay? Then the answer is yes. It doesn't matter whether or not he has no money. then the burden unfortunately falls on, or rather the risk unfortunately falls on the developer to claw back the money from the main contractor. I hope that answers the question.
Moving on, Michael, let's say if you've commenced enforcement proceedings against the main contractor, either garnishee proceedings, and then you find out that the main contractor does have money to satisfy your claim. However, at the same time, you also claim from the developer, and the developer is in the midst of approving the payment. How would you proceed in this kind of scenario?
Oh, the developer is in the midst of approving your Section 30 demand. How would I proceed? I would say get the money. Take the money. Don't risk trying to claw back from the main contractor, because the main contractor has already in the first place ignored, and presumably by your example, if you're saying garnishee proceedings, that means they have resisted you all the way. I would say get the money from the developer and pass on the risk to the developer to bring it from the main contractor. I hope that answers the question.
I think that does, Michael. Okay, for the next question, is the principal bound to pay costs and interest to the subcontractor when the amount due and payable by the principal to the main contractor is lesser than the amount of costs and interest claimed by the subcontractor?
Actually, that's a very good question. I think you are, let's see what the Act says. I think you are bound to pay to the extent that there is monies due and payable. But you would still have to issue a Section 30 sub 2 notice to the main contractor and then run the argument that I'm paying this much only because or rather there's only this amount that is due and payable. So that is actually a very good question, because we've not encountered this situation. I frankly have not encountered this situation, but I would think that the reading of the Act suggests that it's liable only when there's payment due and payable. So once that amount is out, then I don't think the rest of it can be applied. But good question.
Michael, the next question goes back to the previous question where there is garnishee proceedings and then there is also a Section 30 notice. So the question is, wouldn't concurrent action result automatically in risk of double payment? So the situation would be two different judges would order or award payment, and then there would be two orders, but coming from one claim. Wouldn't that cause maybe a confusion in the payments or maybe unjust enrichment?
So therein lies a good question that highlights a problem insofar as clawing back monies is concerned and the process of it. I think I would say look, if I was acting for the main contractor, I would be alive with the situation that's going on with the developer, i.e., if I know that you're already bringing an action against the developer to ask for direct payment and yet you're going for garnishee proceedings, I would be alive with the situation to watch whether or not the decision to pay by the developer comes first before my garnishee proceedings. So if the developer's decision is going to come out, say, the Section 30 application is say going to come out in the end of the month, but my garnishee is only happening end of October, I would be very alive and would be watching the decision of the developer. So if the developer then is ordered to pay and pays, I would run to the garnishee court and tell the court it's already been paid. The developer has paid, they cannot be claiming it now. And that, I think, paints a very different picture from the two cases that we saw, because you already proved that a payment has been made. So to answer that, depending on who you are, which party you're representing, you take a very active role in looking at all the applications that are before the court so that you avoid making double payment. Of course, as the subcontractor, I'll be laughing if the developer or the main contractor didn't take the responsible actions in safeguarding their positions. And if the risk happens, if the double payment happens, then they have to take action and claw back the money from me. I wouldn't bend over backwards for them. Depends on who you are representing.
Thank you for your answer, Michael. All right, everyone, I think that is all the time we have for today. Before we conclude, I have a few announcements to make. First, please join us again for our upcoming talks. There is a list of our upcoming talks which is being posted on the screen right now. Our next talk is on the 11th of October 2023, and the speakers will be Sebastian and Aaron Liu on the topic of how to close up shop, dissolution, winding up, and striking off a company. The talks after that will be on the 18th of October 2023 and thereafter on the 25th of October 2023. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, if you would like to speak to our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat box. To our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.